Well, hey, everybody, and welcome to the April 2024 webinar. And we are going to talk about a $3.8 million verdict today, which is pretty cool. Pretty cool. I'm excited to tell you about the case. Some of you may have some background knowledge, whether you know it or not. And what I plan to do is show you exactly what I showed the jury during the phase one closing. We'll talk about the three different phases and what I asked, how I did it, what worked, what I thought went really well, and what I thought didn't. So that's my master plan here. If you know me and have my number, text and call me anytime. If you don't, please reach out to me. Say hello. Say you enjoyed the video. Say you think this was smart, this was stupid. I like talking about this kind of stuff, which is why I do these webinars. So without any other introduction, let's start talking about the case. So the case was Frazier. It's actually Mildred Collins Williams on behalf of her daughter, the estate of her daughter, Keisha Frazier, and her three children. Those were the plaintiffs, and the defendant was an apartment complex. We sued only the apartment complex because it was self-owned and managed. There wasn't an outside management company, so we had a single defendant case. If you're a Georgia law nerd in here, that makes it a pre-Hatcher / Alston and Bird case, meaning there was no apportionment. Didn't know that at the time, but there would have been no apportionment in this case. But as you'll hear in a second, that doesn't quite matter. So this case was defended originally by one of the very well-known defense firms. Things went sideways, very sideways during discovery, and the defense team, the defense side, including the defendant and their lawyers, were sanctioned. There's a 380 something page, 360 something page order from the Northern District of Georgia. That's actually a separate webinar, which we may have taken down, but I'll put back up. We may have taken it down during this trial, but I'll put it back up if it's not. But the outcome of the defendant and their lawyers, defendant with the help of their lawyers, doing some things that shouldn't have been done, doing a lot of really bad stuff, hiding witnesses, lying about witnesses, destroying documents, lying about destroying documents, giving false information, you name it. The outcome of that was that the answer was essentially struck. And therefore, when that happens, we have a trial about damages. And there were other complications in this case, mainly the issue of punitive damages. But I'll talk about that in just one second. So the timeline for this case is that there was a shooting that happened in 2019, in April of 2019. And our client is asleep, and there's a shooting outside of the apartment that she's sleeping in. We don't really know too much about it. One reason is because they hit a witness and we were never able to talk to him. But that aside, she is shot through the wall while she's asleep, and she is killed. I'll talk about her life here in a second, because that really is the main issue in the case. But after she's shot, that's 2019. We filed the lawsuit in 2020. We sent 2 policy limit demands pre-suit. Frankly, I think they were, excuse me, I think the second demand we wrote was the best one I've maybe ever left this office. And I was pretty surprised that it did not get paid. When it didn't, we filed suit in summer, July, August, something like that, of 2020. We went through discovery, had all those issues I talked about, had essentially a year-long delay where after we found out about the misconduct, the judge took almost a year to write the order. I mean, hundreds of pages in an order is not a normal thing and takes some time. It was comprehensive and thorough. So fast forward to this year, and we're getting ready for trial. The defense lawyers who had been sanctioned for doing all that stuff, they are replaced by the folks at Weinberg Wheeler, which, if you don't know the law firms here in Atlanta, I would say that's one of the best, if not the best, insurance defense firm in town. So those guys defend the case, and going into trial, we had an offer for $250,000. That $250,000 offer was on the table before before the answer was struck, before the judge said, hey, you guys are in trouble. But after that, they actually withdrew that $250,000 offer. And that wasn't on the table until leading up to the trial. They put it back on the table. Our clients, rightfully so, we now know, given the jury verdict, said no, thank you. And we moved to trial. So here's how the trial broke down. The trial was 3 phases. Phase 1 was, what was the value of our client's life, and was there conscious pain and suffering? And if so, how much was that worth? So conscious pain and suffering, value of life. Those 2 things are in phase 1. Phase 2 was whether the punitive damages should be awarded. And phase 3 was the amount of those punitive damages. Why did we have these phases, and why were there 3 of them? The standard phase structure is 2 phases. Phase 1 is, in a normal case, where liability is not already decided. But typically phase 1 is, who should win? How much should the person get for their life and conscious pain and suffering? And should punitive damages be awarded? Essentially, phase 2 is built in to phase 1. And then traditionally, there's a separate phase for how much are punitive damages. We agreed to do 3 phases. The defense suggested it. We agreed because we did not want the jury to give this huge punitive verdict in the first phase and not award a lot for our client's life. Now, why were we worried that a jury would do that? Why were we worried that a jury might say, hey, here's millions of dollars in punitive damages, but for the value of life, we're not going to give very much? And of course, most of y'all know, if you don't, punitive damages in a situation like this, an apartment complex negligence case, a negligent security case, those punitive damages are capped at $250,000. So an award of millions of dollars is reduced down to $250,000, and we wanted to avoid that. So we put 3 separate phases, and phase 1 was only about what was the value of our client's life and what was the extent, if any, of her conscious pain and suffering and the value of that. Now, the reason we were worried about the value of her life is because she had a very, very, very difficult life. I'm going to walk you through it right now. So Keisha was born into a family that she was the oldest, born into a family with a military mom and military dad, born in Germany. Very quickly, her mom moved back to the United States. Dad stayed in Germany, and they got divorced. Keisha was born with severe learning disabilities. Later on in her life, in high school, she would be given 2 different IQ tests, and she would score in the bottom 2% of people her age, which makes you essentially unable to care for yourself. It's a very low functioning person. Nevertheless, she gets through high school and graduates with a special education degree. While growing up, she had a really tough childhood. Some people, I think, would say that she was physically abused. Other people might say that she was the product of strict parents, a strict mom especially, who used behavioral modification techniques, parenting techniques that maybe aren't so acceptable now. She was hit with a belt, hit with books or paddle or whatever else. It was I think a tough upbringing. She also was sexually assaulted as a child. She was raped by her stepfather for years, and also her father was, at least what we believe. So it's pretty crazy. I mean, given that backstory, that she gets to 18 and graduates high school with any degree at all, but she did. And she then went out and got a job working first at Grady Hospital as a part-time nurse, and then later at some daycares where she helped kids. But she wasn't able to keep those jobs. She wasn't able to do things fast enough. She wasn't able to complete tasks. I just don't think she was capable mentally. So at the age of 23 is the last time she is working, and she moves in, and she's never left, but she stays living with her mom. And at the age of 25, she's pregnant and gives birth. She hasn't worked from 23 to 25. But at 25, she gives birth. And a month later, she has a major psychotic break, mental health break. Her mom comes home to her house, and she has her 1 month old newborn baby under her shirt, splashing oil and believing that the devil was going to come and take her baby, which is why she was protecting her with oil and whatever else. Um, her family takes her to the hospital, and to make a very long story short, from the age of 25, a month after she gave birth to her first child, until 37 when she died, so 12 years, she was in and out of police custody, medical custody, medical hospitals, checking herself in or being taken to the hospital, or psychiatric care more than 200 times over those 12 years. So at trial, we put into evidence thousands. I mean, I think it was more than 10,000 pages of records, medical records, ambulance records, psychiatric records, police records. Essentially for those 12 years, the worst parts of her life were documented, because she would go to the hospital and say, I'm experiencing this. She would be arrested and tell the police, I'm experiencing this. And what she experienced over those 12 years was that after the first psychiatric break, she was diagnosed with postpartum depression and bipolar. Over the next 12 years, and very quickly, she's diagnosed as manic depressive, as schizophrenic being one of the worst ones. And the effects of that are suicidal ideations, homicidal ideations. She had a substance abuse problem with crack cocaine, alcohol problem. She was working as a prostitute for money and for drugs. She was choosing to be homeless at certain points. So that 12-year stretch was extremely difficult. And here we have more than 10,000 pages of records that show exactly how bad it was. Exactly how bad it was. Very rarely do you go to the hospital and do you go to, the police station when you are having the best day of your life. So here were the worst moments of her 12 years, documented in great detail by professionals. So it was extremely difficult to trust, I guess, that a jury would value her life highly. And that was what the defense was relying upon. So I'm trying to think of if there's anything else over those 12 years that I think is important to share. Her family was supportive as much as you could expect, but I don't think they were able to care for her in any way. They didn't have any sort of health insurance after she was 25 to cover her, so she didn't have access to medical care that other people may have access to. And during the trial, we repeatedly said that she sought help. That's how we framed, and that's what I truly believe after reading all the records, that she was going to these places looking for help. But her way of asking for help sometimes was really, really tough for the case and really tough to read. She went into a hospital and said, if you don't give me crack cocaine, I'm going to blow this place up. I'm going to blow the country up, and there's, going to be death. There's all kinds of records where you can look at them in one of two ways. One way is that she's an absolutely terrible person who, isn't worth anything, or look at it as this is somebody who's a low functioning adult who doesn't know how to express themselves, has an addiction, has mental health problems, isn't on their medicine, but knows enough to go get help. Depending on how you look at it. And this, depending on how you look at it, and you can almost, I don't know if you can see me with the nonverbal cues that I'm unintentionally giving. I can see both sides of the coin. And this case was a struggle for me. So without giving away what I think, I'm going to explain it to you and show you how we did it in a closing argument. So here, now, I am not a fan of visual dramatics. I might be the dramatic one here. It makes me think of what's that? Hi, it's me, or it's me. Hi, I'm the problem. It's me. That's what my 6-year-old runs around screaming. And she's right. She is the problem. So maybe I'm the dramatic one in closing arguments, but I don't want the visuals to be. So I'm going to show you the PowerPoint. We used a trial, and you are going to be blown away with how simple it is. Like old school Microsoft PowerPoint. And the reason I do it this way, and I'm showing it to you in regular mode, not in presentation mode, so you can see. The reason that I do it this way is because I want a black background in a courtroom because I don't want the lights turned off. If the lights are turned off, I think everybody's going to go to sleep. So I do everything I can to leave the lights on. So black background, white lighting works best for leaving the lights on. I tell the jury what my plan is. I give them an outline because I look at this as I'm teaching. So when I'm teaching, I give a plan. And this is the same plan I'm going to use with y'all. This plan is I'm going to talk about conscious pain and suffering, give the general law. There were 2 important witnesses. We're going to compare them. I'm going to tell you what I think the defense is going to do. And then I'm going to talk about how long she suffered and how you value that. Second topic, we're going to talk about the value of life and the idea of but. And I left it hanging just like that. So how I just said it to y'all is pretty much how I said it to the jury. I said, here's my plan. Here's what I'm going to talk to you about. And I looked at all of them and said, y'all in on my plan? Are we ready to do this? And they said, yeah. All right. So the pain and suffering in the law is taken from the jury charge. So nothing particularly interesting there. If you haven't seen the law, or if you want our jury charges, I can give them to you. But we obviously shortened them. The credibility of witnesses was the next slide, and the federal charges I think are great at giving the jury a couple questions. There's more than these 4, but they give the jury questions to say, here's what you should consider. And the 4 that we thought were important was, did the witness impress you? Did you walk away there and say, wow, that person, they got their shit together? Number 2, did the witness have a good memory? Number 3, did the witness have an opportunity to see everything they needed to see? And then did the witness's testimony differ from other testimony, including the witness's own testimony? So this was the law that we gave the jury. And here is what we were asking them to consider. So after Keisha was killed, she was killed in DeKalb County. She was taken to the DeKalb County medical examiner's office, and there was a autopsy done. And it was done by medical examiner Smith, who is now the head medical examiner at the GBI. And medical examiner Smith, he testified to 2 important things. 2 important things. He said, I'm going to not let you cheat and read ahead yet. He said 2 things. Number 1, she was healthy. She was healthy when she was killed. She was healthy when she was killed. So he wouldn't say it exactly. Never had a more hostile medical examiner, which I think are, in terms of answering what I think are easy questions. For example, if the bullet didn't come and hit her in her heart, puncturing her lung and then her aorta, she still would have been alive, right? And his answer was, well, I don't know. But I think the point was made. So number 1, she was healthy. Her body, head to toe, other than being shot, she was healthy. No disease, no organ failure, no organ problems. She was healthy. Number 2, he said there was no conscious pain and suffering. And he based this on the fact that he didn't believe that she moved, his testimony, and I'm shaking my head here and my hands in my face, because it still baffles me. His testimony was that she's sleeping in her bed, which we all agreed to. It's true. Sleeping in a bed. It wasn't hers. She had gone to a house that night, while she was supposed to be in like a halfway house, kind of assisted living facility type place. She left there without permission. She had been gone for a couple of days, actually, without permission. And she went to a friend's house. She had sex with him, most likely for crack, because they smoked some crack. And then she went to sleep. And she is shot while asleep. She never wakes up, never gets out of bed or anything like that. So when the bullet comes in the wall, everybody agrees it hit her, came in from the back from her. And apologize if this is graphic, but it hit her, went through her lung, punctured one of her lungs, and then hit her aorta. The aorta transfers blood out of the heart to the rest of your body. And the testimony that of how she died, again, disclaimer, this is graphic, or could be considered, is that the aorta is still, or the heart is still pumping blood, but the aorta can't transport the blood. And her right lung, which was not punctured, and her left lung, which partially was punctured, are still trying to breathe. So her body filled up with 2.5 liters of blood, and that was in her chest cavity, and the rest went out onto the bed, and she passed away. And the question or the answer of medical examiner Smith was, yet all that happened. She gets shot. She starts losing blood. She can't breathe. Blood's pumping into her chest and out of her body, and her life is draining out of her. And she didn't wake up because she was just still asleep. And he didn't testify it was because of drugs or anything. He just said she was unconscious because sleep is a form of unconsciousness. And she didn't wake up because it doesn't look like she moved. Which just never made sense to me. It never made sense to me because I can understand that she didn't feel the bullet going through her body, but I've never been able to understand the idea that as her body is failing, she doesn't wake up. I mean, if I cough, if I sneeze, I wake up sometimes. Like think about all the things that wake you up in the middle of the night, and your life being drained from you is on my list of things you wake up from. I think there were also some pictures that showed, or there were some pictures that I think showed that she had moved. So anyway, let me get you back to this PowerPoint. So with Smith, what we wanted to do, and we called him in our case, he was our first witness because our idea was present to the jury everything, give them all the medical records, give them all the testimony. So this was the first witness in the case. And it was a witness we disagreed with to a large extent, or completely, on the pain and suffering. So on the left here, we have the 4 questions, and on the right, we have the things that we thought were important. So the medical examiner is looking at cause of death for criminal reasons. His job is not to look at conscious pain and suffering. That's not what he considers, and there was not mention of it either yes or no in his report. He had no idea if he looked at crime scene photos. He testified he looked at photos taken by the medical examiner's investigator, which is somebody who goes to the scene, usually a former police officer, and takes photos. But he didn't know if he had looked at the crime scene photos, and those were important because the crime scene photos, I think, showed that she had moved. There was a pool of blood that was separate from her body. I mean, blood travels down because of gravity, obviously, and there's a pool of blood next to her. His death certificate was not accurate. I didn't cross him on this because I thought it would look petty. But when we're building up the blocks of why someone is not a credible witness, why they shouldn't be believed, or why their expert opinion shouldn't be trusted, I guess, I thought it was important to point out that the death certificate showed that her time of death was 5 o'clock, or excuse me, the time of the incident was 5 o'clock, and her time of death was 8:15. Which if you just look at the death certificate, you would conclude she had 3 hours and 15 minutes of pain and suffering. Now we know she didn't really have that, and I told the jury, we know she didn't suffer for 3 hours and 15 minutes, but it shows the medical examiner may have some issues with what he has recorded and what his testimony is based on. During the cross-examination I did of him, there were 2 or 3 instances where he said something that was different than a prior deposition, which was a year earlier. So I deposed him in the beginning part of 2013 or 2023, excuse me, the beginning part of 2023, and then trials 2024. So it'd been about a year, and he changed some of his testimony. He called it qualified. Oh, I'm just qualifying what I said. And I thought the jury had a good reaction about the idea that he's just qualifying, because he didn't want to say, yeah, I'm changing it. He said he wasn't sure about movement. He eventually agreed he didn't know if she moved because he hadn't looked at all the pictures, or at least he didn't know. So he wasn't sure if she moved, which that was enough for me. I didn't need the jury to know I didn't need the jury to know that he was totally wrong. I just needed them to doubt him enough. And then I told the jury what I said to you, is that it just didn't make sense. Here, by the way, is the medical examiner's autopsy report, which shows down here in 39, the time of injury, 5 o'clock, and the time of death, an hour pronounced dead, was 8:15, which would lead to the conclusion that it was 3 hours and 15 minutes. Now, let me talk to you about Dr. Bennett Amalu. If you are in my world, you might know him. You might know him. Dr. Amalu was hired by the original defense firm. He was hired for the purpose to show that our client had a reduced expectation of life, meaning she wouldn't live as long as maybe you or me, someone that didn't have the same challenges that she had. But he agreed that there was conscious pain and suffering for up to 3 to 5 minutes. So we called Dr. Amalu. The defense withdrew him, which means I can't then tell the jury that he's their expert. The defense hired him. So we called him second in our case. Started with the medical examiner, called Amalu, and then Dr. Amalu testified that there was conscious pain and suffering. He is extremely highly credentialed. There's no doubt about that. He didn't change his testimony because we didn't cross-examine his testimony. We liked what he said. And his testimony, I thought, made sense. He said that, yeah, she was probably more likely than not aroused, woken up to some degree after, not necessarily after the bullet passed through her body, but after she started experiencing the effects of the bullet passing through her body, all the things I talked to you about, not being able to breathe, not being able to get blood in your body where it needs to go. And that would have lasted 3 to 5 minutes. 3 to 5 minutes was his testimony. All right, so then that brings the question of how long did Keisha suffer for? And the medical examiner said that she was alive for up to 5 minutes, but asleep the whole time, that she remained unconscious for 5 minutes as she died after being shot, and never woke up, never understood what was going on. Dr. Amalu said 3 to 5 minutes, and his end result was this last little slide bullet point that as a result of the gunshot on April 6th, Keisha suffered conscious pain and suffering up to a range of 3 to 5 minutes. So that is how we walked through the two competing experts, the medical examiner who wasn't on our side, the former defense expert who wasn't on our side. But those are the two witnesses that we called in our case in chief. And what I did in closing was I compared and contrasted them. And that's what I wanted the jury to do in the back of, or when they go back in the jury deliberation room, I wanted them to compare and contrast, because I thought we were very careful to give the medical examiner his due regard, be respectful to him, and say, you know, hey, everything you did makes sense in terms of your job, but your job doesn't involve pain and suffering. You do a lot of these autopsies. This one was no different than the other ones you did. You didn't spend too much time on it, and there's some mistakes. So let's leave it there. She was alive for 5 minutes. You say she was asleep. That's okay. We didn't, in the cross-examination of him, and we didn't need to go as far to prove him wrong. We just need to show that there's someone else who's a more believable option, and that was Dr. Amalu. Can't believe I'm saying that. That was Dr. Amalu. So then I said to the jury, how do you value suffering? How do you value the pain and suffering that she experienced consciously before she died? So I told them that first you have to decide how long Keisha was alive for. And I told them I thought it was 5 minutes, that they should use 5 minutes, because Dr. Amalu said 3 to 5 minutes. And the medical examiner said, yes, she was alive for 5 minutes. So I say, put those together. You take the 5 minutes from both of them and you believe Amalu over the medical examiner, and you get to 5 minutes of conscious pain and suffering. And just know that out of all the things that went wrong in her life, all the things that went wrong in her life, her worst days as a child, her worst days as an adult, the days that she maybe thought she was going to die, maybe the days she thought she didn't want to live, those were not as bad as the worst moments of her life. And that's how I left it with jury. And I said, we trust whatever number you're going to give us. One reason I didn't give a number is because I didn't want to anchor a number at this point. So y'all know in federal court, you have to tell the jury what you're asking for in your first closing argument. Then the defense gives their closing argument, and then you give a rebuttal. but you have to explain and say what you want in your first closing so the defense can respond to that. So it was a really tough decision for us not to give a value for pain and suffering, to not give a value of pain and suffering. But we didn't. And I'm glad we didn't. Ultimately, the jury would decide $1 million, $200,000 for 5 minutes. So here's where the case, I think, gets a little more interesting. Our theme in the case was all people are valuable, all people have worth, and all life has meaning. And in their opening statement, the defense agreed to all that. They agreed to all that. They said, yes, we agree all people are valuable and have worth and all life has meaning. And when I thought about their case, this was not this idea of the but that I'm going to talk to you about was not something that occurred to me until after the first day of trial. So isn't it crazy? You spend 5 years working on a case, and then you hear what the defense says in their opening statement, and you think to yourself, shit, I'd have this totally different idea. So this closing argument was very different at one point. And this, in my experience, this happens in almost every case. But, 5 years, and then what you're going to end up arguing in the closing comes the week of the trial based on kind of what you think the defense is going to do and what they do in fact do. So in their opening, they said, everybody's valuable, everyone has worth, everyone has meaning, every life has meaning, but here are these other factors you need to consider. And it made me think of the 10-year-old that runs around in my house. And I say, hey, Charlie, don't yell. Yeah, but Olivia's being mean to me. Hey, Charlie, can you grab your shoes? But I just went upstairs, or, not to leave her out. Hey, Olivia, will you clean up your popcorn? But my show's almost over, or but I'm reading, or but. So I hear but all the time. And frankly, depending on the age of the kids in your house, sometimes the word but makes my blood boil. So I don't know, maybe I'm sitting there the first day of the trial and I hear in the opening statement, and this is what happened. They say, yeah, all people are valuable and have worth and meaning, but, and like, I think my head almost fucking exploded when I heard the but word at that moment. And that stuck with me for the rest of that day. And I was sitting up like at midnight that night, and I was like, shit, this case is about a but. This case is about but. And here's what I mean. Now, for our purposes right now, ignore the blue. Ignore the blue. These are all the buts I could think of with Keisha's life. I'm going to give you a minute here to kind of browse through these. But these were all the things I could think about would be reasons why her life was not as valuable as someone else's, why her life wasn't as meaningful, why it didn't have as much worth as someone else. And it was scary to write this list and then show the list at trial. Because here I am, I'm her family's lawyer fighting for her. And I have a list up of all the things that are wrong, use that word in a general sense, wrong with her life. So I put this list up and I said to the jury, pretty much what I just said to you. I said, look, y'all, I know all the buts. I've been working on this case for 5 years. I get it. And over those 5 years, I have thought about all of these things. And I told the jury, I bet you my butt list is going to be longer than theirs, because I'm going to truly tell you everything possible that I could think of as a reason why you shouldn't award very much money. And here are all mine. And the last one was the scariest one to put on there. She's better off now. I told the jury, that's crossed my mind. Maybe that's a reflection of me as a person, but I think that it's probably crossed your mind. And I had a juror in the top left. The jury would end up being the formula guy of determining how much money to award in the jury deliberation room. He nods to me, yep. And I felt really good at that point. Not necessarily good about it being a person, but I felt good that I had made the right decision to put this list up, because these are all the things that maybe you and I do not experience and wouldn't be on our lists. And there are ways that we could judge someone else and say, look at her life, look at this. But these are only the last 12 years of her life. So, and I'll tell you what I did with the blue in just a little bit, but this is the list I showed the jury. And I said to them, I left them with that list. I left them with that list. And I said, there's no buts. The apartment complex says there's no conscious pain and suffering, and they are going to tell you to award less than $1 million for her life. I had a very, very good feeling. I mean, I had a very good idea that they would say to award less than 1 million. So I put it out there. I said, maybe I'll be surprised. Told the jury, maybe I'll be surprised. Maybe they'll come here and for once they'll give an offer that's a respectful offer. And they'll tell you, that her life does have value and meaning, and they'll put a number out there that makes sense. And if they do, that's great, but it'd be the first time we ever heard it. Our position is that she lived for 3 to 5 minutes, and that human life is worth millions and millions of dollars. Millions and millions of dollars. That was my first close. It was short. We originally only had 30 minutes for closing arguments, and that was expanded the day before. The judge agreed to an hour. This portion of mine was about 15 minutes. It's about 15 minutes. The defense got up and spoke. They did their thing. And what I'm doing, fun fact, this black screen, this is where the first closing ends for me. And then what I'm doing, listening to their closing, is I'm adding slides. So there was something about Smith that they said. I guess it was about movement, because here at the end, the question is, and you're not sure it was a conscious movement? No, I'm not. So he's agreeing that she moved. He just doesn't know if it was conscious or not. So I showed that to the jury. I don't know if you're allowed to show. I've heard both ways. I don't know if you're allowed to show deposition testimony. I'm always of the belief that you can't. If you would have asked me before this trial, I'd say you can't show deposition testimony that was played to the jury. Meaning played as a videotape. You can't show them the testimony. The defense did it in their closing. So I'm sitting there, at the table, and I'm watching them put up, and I'm like, oh shit. All right, let's put it up. So I made this slide sitting there during closing. They talked about, the defense had talked about no lost income. So I told the jury, don't award any money for economic wages. We're not asking you to. She didn't work. No expectation that she would have worked in the future. So they spent 5 minutes talking about lost wages. We're not asking you for lost wages. But notice, and Judge Jones in the Northern District allows the jurors to get to copies of the jury charges. So I knew they'd have the actual hard copies. So I said, when you look through the jury charges, you're going to see the judge said to you, I charge you that the full value of Keisha, she went by Keisha, Keisha's life is not only comprised of an economic component, but the intangible value of life as well. All right. So then we talked about the value of the law, what the value of life, what the law is. And essentially, I mean, for shorthand, anybody who's maybe not a lawyer doesn't do this. The enlightened conscience of a fair and impartial jury. It's whatever the hell they think. So here's the but slide again. Here's what I told the jury. It's not going to be as dramatic. But here's what I told the jury. I said, during the defense's closing, they told you there was no but. They told you that all life is valuable, has meaning, it's worth something. And without using the but, I said defense counsel slipped once and used the word but once. But without using that word, they gave you all the reasons why you shouldn't award very much money. And I've highlighted in blue the ones that they brought up. They said she was abused physically and emotionally. She hadn't filed taxes and worked. She used drugs, couldn't care for herself. She was in a bad situation where her family couldn't help, and she was homeless. She had a child she couldn't care for, and then two more kids. She had two more kids during this 12-year stretch who were adopted immediately by a family friend, and those kids didn't even know and don't know that that's their mother. She had hallucinations and heard voices, fought with her family. She went to jail. She put herself in danger. I thought it was crazy. They said she put herself in dangerous situations so she wouldn't have lived long. You know what dangerous situation she put herself in? Being in that fucking apartment complex that was like a war zone. So you had the apartment complex, and I said this to the jury. I said, so you have the apartment complex who the judge has found is responsible, 100% responsible for this lady's death. That same apartment complex is going to say, hey, look, her life wouldn't have lasted that long if she wouldn't have been shot, because she kept coming to places like our apartment complex and they were so dangerous she was probably going to die. That was their argument. That was part of it. So I showed this butt list and said to the jury, as you can see, their list is shorter than mine. And again, I don't know what that says about me as a person, that I thought of more ways to judge this person. But here's my truth. Here's my truth. My truth is that, oh, I guess I paused. Sorry. I'm going to jump back to the truth in a second. I'm looking at my slides. So I said to value her, I'm going to pause on the truth. I'll tell you my truth in a second. So we told the jury that you should value her life by part one was 25 years. 25 years. No mental health issues, no drug abuse, none of the really bad stuff. You know, she struggled with things during those first 25 years of her life, but they're all outside her control. And part two is 12 years. So I wanted the jury to remember that, you know, her whole life should be valued. And during jury selection, Alex Brown in my office asked the question, how do you value, would you value someone's whole life or just a portion of their life? And every juror said the whole life. So that's why I came back to this. We then talked about how long Keisha would live. Dr. Amalu, again, the defense expert, couldn't say it, gave some information. We used the Georgia mortality table. She would have had 42, let's call it 43 years. Amalu said to reduce, and I did some math for the jury, and we came to 22 to 29 years. I think the jury chose eventually to use 22 years, 22.67 years for how long she would have lived. Part three is a reference to something that was said in closing, that Keisha didn't get to live out her part three, her third part of her life. She lived out part one, which was 25 years. Part two, the struggle, was 2 years, or it was 12 years, but we didn't get to that redemption moment of part three. And this is something the defense said during opening statement. She's Keisha. So Keisha just never could overcome. She couldn't overcome her past, her substance abuse, her sexual abuse, her mental illness. She just couldn't overcome those demons. The path she was on led her to that apartment. And here's the position where I said to the jury, how dare they? How dare an apartment complex be responsible for someone's wrongful death and then come and criticize that person for going to places like their apartment complex? So this is the slide I criticized them about that on. We had a witness who was actually the person who ran the halfway house that Keisha was supposed to be at the night she was shot. And he said that he kept giving her chances and chances and chances, and that he believed that she would one day succeed, and that he was committed to her and would give her chance after chance if she was still alive. So I told the jury that what's another chance worth? And the answer is everything. So Contra-Reestwick's the defendant. They're the apartment complex. This I'm pretty sure this was objected to, but said it because I think it's a fair thing to say. I said, I wonder if they think they got lucky because they're responsible for someone's death, but they happen to be responsible for the death of someone who had all these challenges, as opposed to some healthy, mentally healthy, physically healthy 20 or 36-year-old woman who doesn't have the same challenges that Keisha had. I told the jury, what if Keisha wasn't killed? What if Keisha wasn't killed? What if she was struck by that bullet and paralyzed? She was a quadriplegic. We all, I think, know, using common sense, given the rising costs of medical care in this country, that if you're a quadriplegic at the age of 37, you're going to need millions and millions of dollars of future medical care just to stay alive. If Keisha wasn't killed, can you imagine the apartment complex coming to court and saying, yeah, we know she was shot in our apartment complex, and we know the judge has said we're 100% responsible and totally our fault. But, you know, she's had a really tough life, and I don't think we should give her all the money she needs for medical care, because although she needs it, but she had all these other things. I think there would be a riot in court. They wouldn't be laughed at. They'd be thrown out. I mean, but yet, because she was killed, now we're talking about the value of her life. And if the value of a life, I think, has to be worth more than the medical treatment that you can receive to keep your life alive. I mean, I didn't use it, but feel free to steal this. You know, if you've ever heard of the fighter pilot example, the fighter pilot is driving, flying the plane, and he's hit, or there's a problem with the plane. The U.S. government tells that pilot to eject. Always eject. Do not go down with the plane. The human life is worth more than the plane. So my kind of corollary with that story that I knew about, or that saying that I know, I said, life is worth more than the medical treatment you can receive to keep you alive. I talked about, we had one juror whose son was bipolar. We learned that during jury selection, which maybe Alex Brown, my office, will do one about jury selection. In federal court, you have 20 minutes. So it's tough, but given the issues we had in the case, we had to ask some very personal questions. And one juror said that his son was bipolar. So I looked right at that juror and said, now what if Keisha was a different kind of sick or disabled? What if instead of being bipolar, she had Down syndrome? She was autistic. She was wheelchair bound. She couldn't walk. What if she had CF? I mean, like, what if it was something that we look at as a society and say, yeah, we feel bad, or we understand that disability. We understand Down syndrome. Nobody kind of judges someone as a negative for having Down syndrome, but for better or worse, definitely worse, we do, I think, as a society, judge people who have mental health problems. Oh, they're schizophrenic. They're schizo. Oh, bipolar. You don't hear people criticize or denigrate other people by saying, yeah, you're wheelchair bound. No, they say, oh, you're acting bipolar, you're acting manic, you're acting this, and it's a criticism. So I talked to the jury about what if it was just a different kind of sick or disabled. Would the apartment complex come in then and say, don't award a lot of money because this person is autistic, because this person has Down syndrome? I told the jury that, what if her substance abuse, Keisha's substance abuse, was a white girl from Buckhead who went to Georgia, was trying to be in the popular group of girls, got an eating disorder? Would we judge that eating disorder the same way that we judge Keisha self-medicating by using drugs? So, I threw it out there. And the ending of what I told the jury is what I'm going to share with you now. And it is my truth. It's what I believe. So, over the 5 years I worked on this case, there were days where I struggled. And I struggled because before this case, if you asked me, and I've said this in videos, if you watch my daily videos, if you've watched other webinars, I've said this, and I still say it. I believe that a year of human life is worth more than $1 million. Here's what I told the jury. I told them that, and I said, I don't need you to believe that or agree with me. I'm confident in what I believe about that. So I'm telling you what I think. I don't expect you to agree with me. Maybe you do, maybe you don't. The truth is, I don't care if you do, because I'm going to tell you what my truth is. And my truth is, I think that a year worth of life is worth more than $1 million, because there's GoFundMe's for more than $1 million. And I sure as hell know if Keisha, or anybody for that matter, had the opportunity to live for an extra year and knew they needed $1 million, Keisha would have figured out a way to get $1 million. I think, and I can't say this, I didn't, but I think anybody would. So I told the jury that was always been my belief, that $1 million for a year of life. And then this case comes along, and it shook my belief. It shook my thought on that. It made me think at times, because of the buts, but she's a prostitute who's working on the street, who's doing crack, not taking her medicine, choosing to be homeless, not taking care of her kids, and not working. But all that, there were lots of times during this case that those buts made me think that I wouldn't award a lot of money if I was a juror. And the only other cases I've ever lost, I've lost 2 cases other than, I didn't lose this one. The 2 cases that I've lost, I didn't believe. And I remember the night before the closing argument, I texted Chris Stokes' office and said, I'm having some trouble getting behind this. And he said, well, that's a problem. And he didn't say anything else. And I was, later I asked him, I was like, why didn't you say anything? He goes, yeah, you just had to figure it out yourself. I mean, because I believe you have to believe. I really believe you have to believe what you're saying. And I struggled writing the closing argument. Literally at that slide that I just showed you, I was trying to put, like, what is my end slide? What is my motivating factor I'm going to tell the jury? And I wrote it one way, award a ton of money. I wrote it another way, don't award a ton of money, but award a good amount. I mean, like, I was all over the map. So I decided, rather than fight that, I would just tell the jury that I was all over the map. And I told them that there are tons of nights I sat up and I said, but I wouldn't award a lot of money. And then I told them about a experiment or social study that my wife told me about. So I think it's called a privilege walk. So what I did was, and this is true. This is true that I did this during the closing, and true that this is what shaped my belief. So my wife told me about this privilege walk where kids stand up in a line and in a big field usually, and they're told, if you grew up in a two-parent household, take a step forward. If you're if there's no signs of mental health in your family, take a step forward. If one of your parents has been in jail or prison, take a step back. And I went in the federal courthouse, in that courtroom. I did this walk essentially for the jury. So I went to the back door and stood there. This is where I guess the me being dramatic part. I went in the back wall and I stood there and I said, there's a thing called the privilege walk. And here's how it works. There's a line of kids. Teacher or somebody reads out questions and they're told what to do, kind of like Simon Says. So if your parents graduated high school, take 2 steps forward. If your parents graduated college, take 2 steps forward. If your parents didn't, take 1 step back. If you have a sibling, whatever the things were, a whole list, and I will kind of demonstrate it. And I said, so when I go home, when my kids heard about this and we're asking all these questions about the privilege walk. So, before bed one night, they're saying, hey, Katie was 5 steps behind me, but Lauren was 6 steps ahead of me. What does that mean? Does that mean I'm better than Katie, but I'm not as good as Lauren? Is that what that means? What fucking answer do you give your kids? Do you say, yeah, fuck Katie, but Lauren, she's going to be someone? No. Say to your kids, that doesn't matter. None of that matters. Yeah, that might affect your life, might have some effect on it. But that doesn't affect and doesn't shape and doesn't make who you are. You are you. You are just as good as Katie and Lauren, and they're just as good as you. Everybody's equal. Everybody has worth. Everyone has value. So that's what I told the jury. And I demonstrated it. And I said, no matter if you're the kid I said, there's some kids who go backwards. So whether you're that kid or whether you're the kid who, has Harvard educated parents and has a trust fund and all the great things that you need or whatever, all the way up there, as a parent and as a human, you tell others that shit doesn't matter about the value of you as a person. So what I told the jury was, what I had to decide was whether my words are just words. Is it just bullshit I say to kids? Is it just bullshit I say to make it sound like I'm a good person, or do I actually believe that? And my truth is that even though I've questioned my beliefs and my process and my thinking, my truth is I believe that. And whether you believe it or not, I said to the jury, I said, either award nothing. The defense said to award $500,000. I said, either award $500,000 or even nothing, or award millions of dollars. You can't be in the middle. Fun fact, they were in the middle. But I told them you can't be in the middle and you shouldn't be in the middle, because either you value the life and you value what you tell kids and you value and you believe it, or you don't. There is no middle ground. So that was what I told them my truth was. I told them that if they awarded, $500,000 or less, I was fine with that. But they needed to think about what that made them as a person when they go home to their kids and talk about these issues. I told them that my clients, one day, my clients are the kids, one day the kids are going to look back and be old enough and say, did that jury in Atlanta, Georgia, did they say my mom was worth what a human is worth? Or did they discount her by the things she couldn't control? So I kind of dared the jury. I felt like I had a good relationship with them. I felt like I had a good rapport with them. I did it in a respectful way. I did it in a way that I thought was fair, because I put myself in front and said, here are the things I struggle with, and I imagine here are the things you're going to struggle with. It's probably the realest closing argument I've ever given. Because essentially I started by giving, dealing with the conscious pain and suffering issue. I then gave a defense closing. I said, here are all the reasons you shouldn't award money. Here's all the buts. And then I essentially argued against myself, a la Professor Koonin and UJ Law, and said what I truly believed. So that's what I did. In terms of the ask for the actual number, I told the jury that if it was me, and I'll admit, this was a way of me getting out of, me weaseling a little bit out of telling the jury a number that was an exact number, because if I give, after I've given this whole idea that I think a year of someone's life, no matter who it is worth $1 million, I can't tell them to award less than that. So I told them, yeah, look, if this is me, I award $22 million. If it's me, that's what I do. I don't think you're going to do that, though. I told them that. I said, I don't think you're going to do that. I said, I think you should award more than 5. I think 4 is fair. I think 3.5 is the limit that it makes me think to myself, that doesn't feel right. I said, but y'all need to figure this out. That's kind of how I left it. I did not give a hard ask. I did not on pain and suffering or on the value of life, because I think there were so many booby traps, so many pitfalls here. So I didn't do that. The jury, we talked to them after. They came up with $1 million for conscious pain and suffering, 5 minutes. They said both doctors said up to 5 minutes. They believed that Keisha was conscious, and they gave her $200,000. That $200,000 per minute for $1 million total in conscious pain and suffering was a bargain, was a bargained exchange, was a negotiation in the jury deliberation room, because there were some jurors that wanted to award millions of dollars for her life and some that really did not. So there was a juror, and we knew this. I mean, we knew when he got put on the jury. He was also the guy whose son was bipolar. When we're talking about the value of life, in jury selection, he kind of laughed or scoffed or something, and then said, well, there's a math way you can figure that out. And, not the answer we wanted to hear, but he made our jury because he needed to make our jury compared to the other ones. And so he was kind of the ringleader in the jury deliberation room. And what they did in those tens of thousands of documents and medical records, he found her Social Security disability paperwork, and they used Social Security disability. They took that, they divided it in half. I don't know why it was $15, and they took it down to 7.5, which essentially is minimum wage, by the way. And they multiplied that by hours, by days, by years. And whatever that number was, it was a couple $100,000, like $200,000, $300,000. They decided that wasn't enough for the value of her life. They did it over 22 years. They decided that wasn't enough. And then they just played around with a multiple and multiplied, I think, in the end by 3. So they took the number they came up with and said, that's too low. Let's multiply it by, somebody said 10, somebody said 5, somebody said 0.25. So it was a bargain for exchange. So what I took from hearing about how they came up with the number is, and this is what I always take away, it seems, is that the jurors think they came up with a defendable formula, when in reality, they felt a number that was right. They bargained between them, amongst them, to get to that number, and then they happened to have a way to justify it. To me, the way they went through with Social Security disability, dividing it in half, multiplying by the hours, then adding a multiple to it, all that did was get them to a number that made them feel okay in their heart of hearts. So I don't put a ton of weight in their formula, because if their formula was right, they wouldn't have needed to multiply it, the outcome, because it felt low to them. So the jury came back with $1 million for conscious pain and suffering, and $800,000 and change. The number escapes me at this moment, for the value of her life, which, my first question to the jury afterwards was, that means you valued the 5 minutes that she had conscious pain and suffering more than the 22 years she was expected to live. And the response I got from the jurors was that that was the bargain we had to come up with for others in the group. Others were willing, the faction that did not want to award a lot of money for her life were willing to award more for conscious pain and suffering. So that's where the money went. So I look at this verdict as being a 1.8 and change $1 million verdict for her life and conscious pain and suffering together. And depending on what juror you would ask, they were, in their own minds, allocating that differently. One juror was allocating $100,000 for conscious pain and suffering and $1.7 million for the value of the life. Another juror was saying in their mind, it's $500,000 for her life, $100,000 for a life, but that conscious pain and suffering, I'm willing to give on that. So that was the bargain that went on in the jury deliberation room. And that was the end of phase one. Very quickly in phase two, we did a closing argument with no visuals and just said, here's all the bad shit that's going on in this apartment complex that they knew about. And as crime was going up, security and ways to prevent crime and deter crime was going down. That was essentially it. Crime going up, security going down. That's not a conscious disregard for the known risk. We don't know what is. And then in the phase three about the value of punitive damages, I will show you the most basic slides you can get. Again, this is purposeful. The apartment complex was bought in 2017 for $23 million and change, sold 4 years later for $36 million. There was testimony, but no documents, no proof of any kind from the apartment complex that they made $8 million of improvements. So we told the jury that, look, if you believe that, the profit was $4.3 million. If you don't believe that they did the $8 million of improvements, then their profit was 12 and change. And we told the jury, Alex Brown did this closing, told the jury, we don't think these people should profit when they're responsible for someone's death. And what the jury did was they erred on the side of $8 million of improvements being put in. The justification, what they said, it made sense to them that $8 million of improvements were made because otherwise the property wouldn't have sold for a $13 million profit. Given the years that this apartment complex was bought and sold, I respectfully disagree with them, and knowing that jack shit was done to the apartment complex. But they took that $4 million number. They estimated how much employees were probably paid, and then they factored in taxes. So they came up with a $2 million number because they thought that was the actual, something like the actual in-pocket profit for the apartment complex. So they did what we asked them to do, and they did it in their way. We have no problems with that. It will be reduced down to $250,000. And the jurors were extremely, extremely mad to learn that fact, as they always are. Very mad that they spent a considerable amount of time coming up with a number that won't matter. That won't matter. So the takeaways from this closing to me, I reaffirmed some things that I always believe, and I learned some new things. So 3 things that I reaffirmed that I've always kind of believed is that you have to be completely honest. You have to be yourself. And that's what maybe made this case so difficult for me, is because I wasn't comfortable being that honest and telling the jury what I really thought until the very night before, where I finally kind of came to and said, all right, just going to do it. I walked around my house talking to my wife, and I walked around my office talking to everyone, saying, like, can I say this? Like, can I actually get up in court and say all the reasons why her life might not have value? And eventually I kind of got the confidence to do that. So that's the first thing, is if you believe something, maybe more importantly, if you don't believe something, you don't say it. You can't say it. The jury will sniff that out so quickly. The second thing that reaffirmed to me is that I don't think you need a huge song and dance and pony show visually with graphics and stuff for a closing argument. You know, the jury at that point, they either get it or they don't. So I err on the side of these very, very basic slides, because I don't want their attention to be on my slides. I want their attention to be on me and my words. So I almost don't want to make the slides, so attractive that they're like, oh, that's really cool. Let me look over there. I just want to reiterate the same things. And the third thing that I learned is that I continue to believe, at least, is that jurors are going to do what they feel is right, what they feel is right. So, just hearing about what their deliberation was like, that feeling where, I told the jury I would award $22 million, but I can understand you won't. That won't feel right to you. But maybe 5, 4, or something like 3.5, that range feels right. And anything below feels wrong. That's what they did. I mean, they went by feeling. The 3 things that I kind of learned that are new things that I learned. The first thing I learned is that, trying to think how to say this. The first thing I learned is that there are a lot of ways to value a human life and a lot of ways are going to upset people. And in a case like this, we went through all of the different ways we could value human life, all the ways I could possibly think and imagine, and we went through all that. But I learned, I think, that it's okay to not give a number, which I've always given a number in every other closing. This is the first time I didn't give a specific number and explain exactly how I got to that number. That's okay. I think that's okay. I think you should give wide parameters at a minimum, but I don't think you have to give a number, especially when the number is, especially when there's going to be such a wide array of opinions about the number. So I always thought, if you asked me a year ago or even 2 months ago now, oh, so-and-so didn't give a number in their closing, I'd be like, baby, afraid. I'm not going to say the other word that comes to my mind, but I'd like, I'd think that. And I'd be like, sucker, couldn't come through, was afraid. I think it's almost, in a way, it's more powerful to not give a number because you're truly showing the jury that you trust them. So anyway, the second thing that I learned in terms of a closing argument is that for me, I had to be mostly behind a podium for this closing because in that courtroom and that court reporter, they want you talking to a microphone. So I had to really think about how I was going to present a visually acceptable and interesting closing argument. When I did the example of that privilege walk, I was basically screaming to make sure the court reporter heard me from point A to point B. In fact, when I turned to her, I'm at the podium and I looked at her and I was kind of wound up. Y'all know how I get. I looked at her and I said, "Don't worry, I'm going to yell." She looked at me and then I just walked to the back. I wasn't going to ask for permission. I just walked to the back and said, "There's this thing called a privilege walk. And here's how it works." So I still was able to build in some of that and show it visually where people end up. But it made me, frankly, focus just a little bit more on my content. It made me, if I'm going to stand in front of you on a podium and, there's no Mike Rafey show. I'm just here in this podium. I always, obviously content is the most important thing. I'm always thinking about that. But there was a little bit more where I said, if I'm going to stand in front of this podium and just speak at the jurors and have essentially no movement, I need to make sure my shit is tight and locked in and my content is perfect. So this was the most content focused I've ever been. And I'm going to continue to do that every single time. All right. The third thing that I've learned, and this is probably the toughest, is that you have to, if you're in a challenging situation like this, you have to make sure that you address it with your clients before you do it. And I did. So I'm glad I did. But, I said in front of my clients that Keisha was abused as a kid. I said in front of my clients that she had a really bad childhood and that her mother couldn't care for her. I said in front of my clients that she wasn't a good mother, obviously. I said that she didn't get the help that she needed from her family. I said that her mother pulled a gun on her, and that's not normal. I said all that stuff, and I said it in front of my client. What I told my client before I didn't tell exactly what I was going to say. I said, I'm going to tell you what I think the evidence showed, and I believe some of this. So I want you to know that I'm doing my job. I think this puts us in the best position to recover for your grandkids, and I need you to trust me. And for the 5 years that I've known that family, almost 5 years now, they've done nothing but trust us, which I think it's a combination of us doing a really good job of communicating with them over the years, making sure they understand the issues, and also us having results. The results in this case where having the answer struck, having a defense expert become our expert, having a medical examiner not look credible, and all the other witnesses that we had. So I think I built up that rapport, but I learned that that checking in with a client to make sure they're okay as a human, as a person, is really, really important. Because I can think of one other closing that I said something that probably wasn't taken well by my client, that I hadn't kind of mentioned to him before, frankly, because I didn't know I was going to say it. But I thought, this is something that's now in my mind and my purview, is that, to make sure that clients know what to expect. Because obviously it occurred to me in this case, if I say this stuff without clearing it or mentioning it to my client, the jury's going to look at her. Jury's going to look at her during the closing and say, your lawyer's saying this shit about you. So I told the jury, I said, look, my client knows what I'm going to say, and she doesn't agree with all of it, but I'm going to tell you what I think the evidence shows. So those are my three kind of takeaways on each side. First closing that we've done in federal court in a case like this. So that was an interesting aspect. So let me look and see if there's any questions and answers that I can get to. All right. So Bill asked on jury selection, did you do anything to determine those who might be hearing challenged? And if so, what did we do? We did not. Didn't come up anything about hearing challenged people. I have had folks on jury panels in other cases that didn't speak English or couldn't understand English, but they kind of flesh themselves out for the most part. Don't respond to a judge's question or don't say anything, and then the judge kind of steps in. But we didn't have anyone who was hearing challenged, other than maybe the court reporter who was adamant about talking into the microphone at all times, minus the time that I just didn't. Any other last minute questions y'all have? I appreciate everybody watching this webinar. I hope this helps. What I'll encourage you to do, is use your visuals as a roadmap to keep yourself organized and on track. But don't put everything in your visuals. Don't make the jury, don't make yourself the sideshow. You are the person that the jury has to believe and trust, because it's you asking for the money, not your visual. Jury doesn't think, oh, your visual is so trustworthy. Oh, I believe your visual. They believe you. So if you have the credibility, and if the jury, is relying upon you as an expert in the courtroom, an expert in the facts, you're the one that knows the facts the most and explains them. You're the one making the most logical conclusions, even sometimes when those conclusions don't help you. You're the ones being real with them. Then ultimately, when you ask for that number, whatever it is, or you tell them how to come up with a number, they're going to rely upon you and trust you. So, for all the shit that us personal injury lawyers get, that we are, if you've ever read my comments on any of these social media channels that I'm on, YouTube, TikTok, Instagram sometimes, we as personal injury lawyers are scum of the earth. We are terrible people. We are hurting businesses and people, increasing insurance rates. We are the death of this country. We deserve to be hanged. Someone told me that the other day in a comment. In reality, I think all the good lawyers I know and all the people that I talk to, we are striving to be the most honest and accurate and credible people in the courtroom, because one, that reflects best upon us. Number two, it helps our clients. And number three, it gets the jury to the right result. And the right result in cases where people are injured is to get the most amount of money that you can get for them. That is our version of justice in the civil justice system. So that's my 2 cents here. This case is not done. This case is not done. There's a lawsuit going on about insurance coverage because after the sanctions were ordered and after the judge decided that the apartment complex was completely responsible, the insurance company then turned around and sued the apartment complex and said that we're not going to give you insurance coverage. So this case doesn't seem to be near its conclusion. We have 2 lawsuits going on. We've won the first, and now we essentially have to work with the apartment complex to make sure they have insurance coverage because they sold the complex. So that's my story. That's this case. We will do some other webinars about this. Obviously jury selection is always one people want to talk about. I think that the witnesses that we did in this case, I have a lot of them on videos, and I've thought about ways to kind of cut those to show you what we were doing, why we did it, and how we did it. But I'll work on that. I appreciate you joining me. My last plea, if I don't know you and you're watching this webinar and you're a lawyer out there and you're saying, Mike sucks, Mike's great, Mike's anything, send me an email. I don't care if you send me an email that says Mike sucks. It says, you suck, Mike. I watched your webinar. You suck. Hey, at least we've met, and I now can cross you off the list and say, I'm not going to talk to you because you told me I sucked. Or I may agree and say, yeah, I kind of did suck. Why did you think? hopefully you'll send me an email or something that says, hey, was on your webinar, maybe enjoyed it, maybe didn't, but I'd love to connect with y'all. This is part of the reason I do these webinars. I want to connect with people.